Welcome to those who've already joined. I'm just going to wait a few moments because more people are joining as I speak. So before we kick off, I just want to make sure that we've got a good number who have joined. Okay, well, there are a few more people who registered than we have online at the moment, but I think we'll kick off. And firstly, just to apologise that we were a few minutes late. That was just due to some technical issues at our end, so many apologies. I know your time is precious, so thank you for bearing with us. Just to introduce myself, I'm Philippa Childs. I'm a Deputy General Secretary of Prospect, and I head up the Bectu sector of Prospect. And joining us today is Rakesh Patel, who is a partner at Thompson solicitors, who are the solicitors that we well, certainly in the Bectu sector, we've always worked with, but going forward are working with across the whole of Prospect. So welcome, Rakesh, and thank you for your time. And also Marion Scavell, who's the head of our legal services department in Prospect, who manages the department which deals with all of the cases, including those in the Bectu sector. How we intend to proceed, I hope this is okay with you. Rakesh is going to talk to us a bit for a few moments about the race discrimination law and what it provides for and what it doesn't. And then Marion is going to talk about Prospect's legal services more generally, how we tend to manage cases across the union. But most importantly, of course, there will be an opportunity for you to ask any questions you might have, whether that's about the law, about your own situation, or about the union's legal services. So feel free to put those into the Q&A, and once the presentations are complete, I will obviously pick some questions out to ask whoever is most appropriate on the panel. So thank you very much, as I say, for your patience, and I'm going to hand over to Rakesh now. Thank you, Rakesh.
Thank you. Thank you for inviting me to speak today. I'm going to be doing a very quick sort of overview of race discrimination law and how it applies in the workplace, and also sort of try and hopefully sort of give you a practical analysis of the law. And towards the end, I'll try and give you some tips on what you can do if you're a rep, helping members, or if you're a member yourself and you've got some problems relating to discrimination and race discrimination in particular. So I'll start off with the next slide. Thank you. So these are the things I'm going to talk about. Firstly, I'm going to talk a bit about what race actually means in law, who's covered by the legislation, the sort of key concepts of the types of discrimination, the burden of proof. By burden of proof, we mean, who has to prove the case, what sort of proof you need, how does the burden of proof apply in practice in a tribunal hearing or court hearing, some practical tips about how you challenge employers, and then I'll talk about time limits and remedies. So next, please. So the definition of race is non-exhaustive, but it's defined under Section 9. So it includes colour, nationality, ethnic or national origins. Ethnic or national origins, there's no definition within the Act, but there's been lots of case law about what constitutes ethnic origin. And in order to be part of an ethnic origin, in order for a group to be defined as an ethnic origin, that group has to have a long shared history and some kind of cultural tradition which dates back generations. So I'll give you some examples of what the courts have held to be ethnic groups which come within the definition and groups which haven't. So Sikhs have been defined as coming within an ethnic group, as have Gypsies, Scottish traveller community, Jewish people. And you might find surprising that Rastafarians have been defined not to be an ethnic group. Reason why, there was a case that went to the Court of Appeal years ago. A black man who had dreadlocks, who was a Rastafarian, who applied for a job as a van driver. At the interview, he was told that if he was offered the job, he'd have to cut his dreadlocks. He refused and brought a claim for race discrimination. The employer admitted that it was the reason for the refusal to give him a job was because of his hair, and that meant because he was Rastafarian. However, the employer argued that Rastafarians aren't protected under the then Race Relations Act because they weren't an ethnic group. And the court upheld the employer's defense on the basis that Rastafarians didn't have a distinct enough identity, and a distinct enough identity that separated them from the Afro-Caribbean community generally. And they were seen to be a religious sect rather than an ethnic group. Nowadays, that sort of distinction wouldn't necessarily matter because there were regulations, and now which form part of the Equality Act, which prevents employers from discriminating on grounds of religion as well. So a Rastafarian would fit in to the definition of religion rather than race. But it just gives you a sort of flavour of the type of things that a court would look at. Now, the fact that a racial group comprises two or more racial groups doesn't mean that it doesn't constitute a particular racial group. Now, that sounds more complicated than it is. So someone like me who's a British Asian, that means I've got two racial groups, but I can also have a distinct separate racial group of British Asian. So nowadays, we don't really get many cases where the definition of race is an issue, but it's worth just bearing in mind those definitions. Next, please. So who's covered by the Act? And applicants for jobs are covered, casual and agency workers, employees and workers from day one. So some of you may know that for some of your employment rights, you need to have a certain length of service before you can get the benefit of those rights. So for example, for unfair dismissal, you'd have to have 2 years continuous service before you can bring a claim for unfair dismissal. That's not the case under the Equality Act. So under the Equality Act, you're protected from day one. And even ex-employees are protected. So if you get a poor reference because of your race, or you get a poor reference because you brought a claim against your ex-employer, you may be able to bring a claim for victimization or direct race discrimination. And I'll go on to those sort of definitions in a minute. So you can see, vast majority of people are covered in terms of depending what, it doesn't really matter what status they have in the workplace, they'll be covered by the Act. Next, please. So I now want to go on to sort of the various different types of discrimination. The first type of discrimination is direct discrimination. So this occurs where a worker is treated less favorably because of race than other workers not of the same race, or who would have been or have been treated. So essentially, you have to show that you've been treated less favorably because of a comparator. So you'd have to show someone who has been treated differently and more favorably than you, or If you don't have a comparator, then you can use a hypothetical comparator. So you'd show that if you'd been of a different race, you wouldn't have been treated in the way you've been treated that you're complaining about. Now, note that the definition doesn't talk about, it says because of race, not because of the claimant's race. So that means anyone associated with someone of a BAME background can bring a claim. So if a claimant is in a relationship with a person of a BAME background, and they are being treated less favorably because they're in a relationship with the person of a BAME background, you could bring a claim because the treatment meted out to you is because of race. It's not because of your race, but just simply because of race. If an employer perceives someone to be of a particular racial background, even if they're not of that background, you can bring a claim. If you refuse to comply with a discriminatory practice, you can also bring a claim. So, for example, there's been a well-known case years ago of a receptionist in a car hire and motor hire service, where she was told by her manager that if anyone with a black name or an Asian-sounding name rings to hire a car, you mustn't hire the car to them. She complained about that, was dismissed, and she brought a claim. Now, she is white, but she was still able to bring a claim on the basis that, although it wasn't to do with her race, the reason for her dismissal was still connected to race because she complained about the discriminatory practice and she wouldn't comply with the order to refuse black people the hire car. Unlike indirect discrimination, direct discrimination can never be justified, other than if you're complaining about age discrimination. Okay, so any other type of discrimination, direct discrimination can never be justified. Next, please. So we've already talked about, We've already talked about less favorable treatment. So that's, you have to compare yourself to another person. But this is really the crux of direct discrimination law. What you need to understand is when you are complaining about less favorable treatment, you have to show that someone in the same circumstances or not materially different circumstances has been treated more favorably. So examples could be if you go for a promotion, you apply for a job, you don't get the job, and you are at the same grade, but you perform better at the interview, your application's better, your references are better, but you're not appointed, and someone of another race, so someone who's white gets the job and you're black. Their circumstances shouldn't be different to yours. So provided they've got similar qualifications as you, they've got the same kind of experience, you can use them as a comparator. Similarly, if you're disciplined at work for something that's reasonably minor, but you get a final written warning, but in the same circumstances, someone of a different race got a verbal warning. You may be able to argue there, if there's no other reasonable explanation, that there could be discrimination. So when you're looking for the less favorable treatment, remember that you have to show less favorable treatment in comparison to someone in the same circumstances or not material different circumstances to you. And you have to then show that the reason for the treatment is because of race. Now, race doesn't have to be the only reason, provided it's played an influential part in your treatment. So I've got a case there called Owen and Briggs versus James. It's a well-known case of a black woman who applied for a job as a secretary with a solicitor's firm. She didn't get the job. She subsequently saw another advert for the same job. She applied again. When she came for the interview, she was told she shouldn't have applied, she'd already been rejected, and she wasn't suitable. She subsequently found out that the person who actually was appointed was white, and was told by the manager, why would we employ an English girl? So why would we not employ, why would we employ a black or non-English girl rather than employ an English girl when there are plenty of English girls available to do the job? So Ms. James brought a claim for race discrimination, and the employer argued that although she had a better typing speed than the white successful applicant, she didn't have the same level of experience, and that's why she didn't get the job. And had nothing to do with race. And the employer also argued that race wasn't the sole reason. And the Court of Appeal said, well, that was nonsense, because it was clearly race played a significant part in that decision. And she was able to establish that as long as race plays some part, you'd get home in that type of case. There's certain cases where you may not need a comparator, where something is so inherently discriminatory that you wouldn't need to show a comparator. Usually, this type of case generally applies in sex discrimination cases, where there's been lots of case law in the past when women who are pregnant were treated less favorably, and employers used to try and argue, well, that's not discrimination, because a man in a similar position who was sick has been treated in the same way, and the courts held that you can't compare the two because being pregnant only applies to women. Similarly, in race cases where there's clearly sort of discriminatory comments, racist comments, racist adverts, you wouldn't need a comparator. So if there's an advert which says travelers needn't apply, that's so inherently discriminatory, so you wouldn't need a comparator in that kind of situation. Now, motive is also not relevant for direct discrimination claims. So it doesn't matter why an employer treats someone less favorably because of their race. Provided race played a part, the employer has no defense. So that Amnesty case is a really interesting case. So Ms. Ahmed is a Sudanese woman, was employed by Amnesty International. She applied for promotion for a job that was based in Sudan. She was shortlisted, and then Amnesty told her that they weren't going to take her application further. And the reason Amnesty gave was because she was Sudanese and the job was going to be based in Sudan. They would be worried about her safety because of the civil war and the conflict in Sudan. They were worried that as someone working there with a specific, distinct ethnic origin, which was Sudanese, but may be seen to be part of one faction in the civil war. And Amnesty, so that was to protect her, really. And Amnesty were also worried about damaging their impartial reputation of impartiality. She resigned and brought a claim for constructive dismissal. And Amnesty argued that this wasn't about race, it was about the reason for the treatment was to protect her and to protect Amnesty's reputation. And the EAT said, well, that doesn't really work, because the real reason for the treatment was because of her Sudanese origin. Whatever the motive was, and the EAT accepted that the motive was benign, it still meant that the decision was based on race, and therefore she was successful. Next slide, please. So I want to move on to indirect discrimination. Indirect discrimination occurs when an employer applies a provision, a criterion, or practice, PCP, which is applied equally to everyone in the workplace, but in comparison, those of a particular race are disadvantaged because of the PCP. And you'd need to show three main things. So you'd have to show, one, that the PCP puts those of the same race at a particular disadvantage, and then puts the claimants themselves at that actual disadvantage, and that the employer cannot justify it. Remember I said earlier that direct discrimination can never be justified. Indirect discrimination can be justified. The best way to sort of illustrate this is by a couple of examples. So if an employer advertises a vacancy and says that the successful applicant must have a GCSE in English obtained from a British school, that applies to everyone who wants to apply for that job, that requirement of having GCSE English from a British school. However, people who may have had a GCSE English level qualification from a school abroad, say from the Caribbean, they'd be put at a disadvantage because they can't comply with that requirement. And it'd be very difficult for the employer to argue that was a justified PCP. Similarly, this is another example, but this is a sex discrimination example. The fire brigade used to have a height restriction, so you couldn't become a firefighter. I can't remember what the actual height restriction was, something like 5'6", 5'7". So that applied to everyone. But in practice, women were disadvantaged because women tend to be shorter. And to be honest, a fire brigade can't really justify that kind of PCP because you don't just need to be big and tall to be a firefighter. Often, fires, you need smaller people to go into buildings, into small spaces. And so those cases were ultimately successful, and women were able to show that was indirect discrimination, and the practice stopped. Next slide, please. So remember, when I said a practice, criterion, or provision, it can be formal policies or written rules, or it can be informal practices. So it could be, a flexible working policy. It doesn't have to be a policy, but a manager tends to refuse people to come in late, to start late and leave late. Now, women may be able to show that actually impacts on them, has a disparate impact on them because they tend to be child carers. They tend to be the ones who drop the children off to school. So they may say, well, that impacts on me, even though that applies to my male colleagues. In practice, women may find that more difficult to comply with. You have to show there's two types of disadvantage for indirect discrimination I talked about earlier. So you have to show the group itself. So in the example of the GCSE, you'd have to show that if you come from a Caribbean background, you went to school in the Caribbean, and you got your GCSE English in the Caribbean, you'd have to show that anyone coming from your background wouldn't be able to comply with that requirement, but also that you yourself can't comply with it. So you'd have to show group disadvantage and individual disadvantage. And in order for the employer to justify indirect discrimination, they'd have to show that the PCP is a proportionate means of achieving a legitimate aim. What that means is that the employer, in the GCSE example, the employer would show that it's an aim of the business. You need to have GCSE English to do the job. That's perfectly legitimate aim. And if that's all the employer asked for, it'd be very difficult to argue that was indirectly discriminatory. But when an employer says it's a legitimate aim to have a GCSE from a British school, it'd be easy to disprove that, and therefore it wouldn't be a proportionate means of trying to achieve that aim. So really, what the court would do is to balance, carry out a balancing exercise, the impact of the discriminatory treatment on the claimant as balanced against the requirements of the business. So is it reasonable for the employer to have that rule compared to the disadvantage caused to someone to whom that rule causes a disadvantage? Now, I just wanted to quickly talk to you about a couple of cases that I know prospects have been involved in, just to illustrate what indirect discrimination means and how it applies. There was a case brought against the Home Office, which went all the way to the Supreme Court. A case about promotion. And in the civil service, you need to pass what's called a skills test to get a ticket. So you need to apply for promotion. You get, it's a sort of psychometric test. So you pass your test, you get a ticket, and then that enables you to apply for jobs at a higher grade. Now that test was shown to be, even by the Home Office's own research, was shown to be discriminatory against Black employees and older employees. They couldn't tell why the test discriminated against them, but it certainly showed that the results were pretty stark. It was a much lower percentage of pass rate. At a preliminary hearing, the tribunal held that in order to be successful, the claimants all had to show that they could that disadvantage caused by the PCP was as a result of their ethnic origin or their age. And there was no way you could prove that. All you could prove was that the test results showed that Black people or older people were much more likely to fail. So one point about what you have to prove in order to show indirect discrimination, show group disadvantage as well as individual disadvantage, went all the way to the Supreme Court. And what the Supreme Court said was that there was nothing in the Act which required you to prove for an indirect discrimination claim why the PCP causes that disadvantage. All you had to show was that disadvantage was caused by that PCP. You wouldn't have to show whether the PCP, why the Black person or the older person found it more difficult to pass the test, provided you were able to show sufficiently with statistical analysis, statistical data, that there was that disadvantage. So when you look at direct discrimination, the causal link has to be between the less favorable treatment and your race. Whereas with the PCP, with the indirect discrimination, the causal link has to be between the PCP and the disadvantage you suffer, and nothing to do with your race or your other protected characteristic. The employer tried to argue, well, in that case, people who would have failed the test anyway, who are very poor employees, who may have turned up late for the test, who didn't complete the test, could piggyback on the stronger cases. And the Supreme Court held, well, that was just a matter of evidence. You could easily show, if an employer knew that an individual who hadn't passed the test was able to show that person turned up late for the test, or was so poor, was such a poor employee that they wouldn't have passed the test and wouldn't have been promoted anyway, and that was just a matter of evidence. But where you couldn't show group disadvantage, it would be putting too big a hurdle in front of employees or workers in order to try and prove the disadvantage and what caused the disadvantage. Next slide, please. The third type of discrimination I want to talk about is harassment. And harassment under the Equality Act occurs where there's unwanted conduct, which has the purpose or effect of violating a person's dignity, or of creating an intimidating or hostile or degrading, humiliating or offensive environment. So there's two types of harassment, really. Where someone purposely causes someone's dignity to be violated, or where someone's conduct is sort of careless, and they then do that. They don't mean to necessarily harass someone, but are careless enough that the impact of their behaviour does cause someone's dignity to be violated. So I've got that case there called Richmond Pharmaceutical versus Dhaliwal. As Dhaliwal is of Indian origin, she was leaving Richmond Pharmaceutical to go to another job. Just towards the end of her employment, she had a meeting with her manager, who said, "Well, I hope I do bump into you somewhere else after you've left, as long as you're not married off in India." She took real offence at that, was very upset, and brought a claim for harassment. The employer was able to show that he didn't really mean anything by, the purpose of his comment was it was a sort of ill thought out throwaway comment, is what the employer said, which is what the tribunal accepted in evidence, that he didn't mean to cause her offence. And the EAT said, well, that didn't really matter, because regardless of whether he meant to or not, the effect of his words and his statements was that it violated her dignity. Now, the test for harassment it's a sort of subjective as well as an objective test. So what the court would look at is how does that the treatment that you're complaining of, the unwanted conduct or the words in this case, and how did it affect that individual, the victim, but also would it be reasonable for that person to have that kind of reaction. And in that Dhaliwal case, the EAT upheld the claim, but said that it was her reaction. She was so upset that it was borderline whether actually it did violate her dignity, because taking the whole case into account and the background, some other people may not have been intimidated or felt upset by that remark. And the courts warned employers and the EAT warned tribunals to be aware of hypersensitive claimants. I mean, my view is it's pretty difficult not to be upset by that remark, and I think most women would have been upset by that kind of remark. So I don't think there was anything borderline about it. Both for direct discrimination and harassment, there's a defence available to an employer. So if an employer can show that they took all reasonable steps to prevent the harassment or prevent the direct discrimination from occurring, then they may have a defence, even if the conduct is found to be discriminatory. So usually you'll know that an employer can be vicariously liable for the actions of their employees, but they wouldn't be liable if they can show they've taken reasonable steps to prevent that type of behaviour. Usually you get this sort of defence relied on by employers where there's a very serious case of harassment, and I've seen cases where some really horrific race discrimination cases, some horrific sex harassment cases, where an employer says, yes, that was awful, their behavior, but it's got nothing to do with us, because we've got all these policies, we've got equal opportunities policies, we have notices up everywhere. You can't use racist language, you can't intimidate your colleagues, you can't sexually harass your colleagues. Now, most of the time those sort of defenses fail because it's not enough just to have a tick box exercise by having these policies. But where those sort of defenses succeed is where the employer shows that they've taken some real proactive steps to train their staff. Just say, we will not accept this kind of behavior. We will not stand by you if you behave in this way and what you do is wrong. In those sorts of cases, what often happens is that the employer will cut that employee loose, won't defend the case. They'll defend the case using this kind of defense, but they won't defend the conduct. So you often end up having to sue both the employer and the individual. And in a discrimination claim, you can bring a claim against both your employer and the individual perpetrator. And there have been some cases where an employer may have been found to have succeeded in that reasonable steps defense, but the claim still succeeds against the individual employee. Next slide, please. This is another type of discrimination, victimization. Victimization occurs where a worker is subject to a detriment because they've carried out a protected act, or the employer believes they've done or may do a protected act. So the victim doesn't have to have that protected characteristic. All they have to show is that they've done a protected act, or the employer believes they've done a protected act or may have carried out a protected act. And next slide, please. So the protected act means that you've brought a claim alleging race discrimination, or you put a grievance in alleging race discrimination, or you've gathered information or evidence about race discrimination, or you've been a witness for someone else in a race discrimination case, either in the tribunal or in a grievance or disciplinary hearing at work, or you've made an allegation of discrimination, or you've done anything under the Act. If, as a result of you carrying out that protected act, your employer treats you less favorably, then you've got a good claim for victimization. So an example could be that you bring a claim or grievance for race discrimination. Later on, you're overlooked for promotion. And you can establish that the reason why you were overlooked for promotion was because you complained about race discrimination, and this was your employer's way of punishing you. And that will be a sort of classic case of victimization. Or where you've helped, so you're white, you've helped a black colleague complain about discrimination. So you've gone and given evidence in a disciplinary hearing, as a result of which your employer then treats you less favorably, punishes you somehow, doesn't give you a bonus, gives you a warning without any justification. You can, as a white person who's helped your black colleague, you can bring a claim for victimization because your treatment has been on, your unfavorable, less favorable treatment has been on grounds that you've carried out a protected act. Now, where you make a false allegation of race discrimination, which is obviously false, and you then believe that allegation anyway, and you then try and rely on that, you wouldn't get anywhere in the tribunal because you'd be bringing your claim in bad faith. Next slide, please. So those are the different types of discrimination: direct, indirect, harassment, and victimization. But those are all sort of reasonably simple concepts on proving, on showing direct discrimination, indirect discrimination. But the real issue is, how do you prove discrimination? You know, what sort of evidence can you gather, and who has to prove discrimination? Because nowadays, most of the time, discrimination is very subtle. You know, it's not overt. It's you very rarely get cases where there's sort of such clear evidence, and we've got one at the moment against a big sort of supermarket where it's been, you know, horrific sort of racist language, notes left in their pigeonhole. And as soon as you get that kind of case, usually the employer is there with an open checkbook trying to settle it because they don't want reputational damage. So most of the time it's very subtle and it's quite hard to prove. In the tribunal, because the burden is on the claimant to prove your case, not on the employer to disprove the case. The easiest way to understand that is if you bring an unfair dismissal case, the onus is on the employer to prove that your dismissal was fair. Whereas in a discrimination case, the onus is on you to prove that whatever you're complaining about was discrimination. But it's a sort of two-stage approach that the tribunal have to take. So you'd have to show an initial case. So you go first with your evidence in the tribunal hearing, usually. You'd have to establish facts from which a tribunal could potentially find discrimination. So the promotion example I gave earlier, so two people go for a job. The black person is better qualified, has more experience, but the white person gets the job. And the black claimant is able to show that. Now, that may be a sort of case where you can initially establish a case. Once you establish that, yes, there is something for the tribunal to consider here, this does look like there is potential discrimination there, the burden then shifts to the employer. The employer then is to provide an explanation. And if the employer can't provide a non-discriminatory, reasonable explanation, then you'd win your case. So in that kind of case, an employer may be able to say, well, yes, they are better qualified and they've got more experience, but we've got a very strict recruitment policy. We interview people, we keep scores, we have set questions, and unfortunately they perform really badly on the day, the black applicant. In that case, you know, the tribunal may well find that the employer's defence is successful because they provided a reasonable explanation. Next slide, please. So I've just got some sort of tips there on what you should be looking out for when you look in practice when you're trying to challenge employers. And this could be not just in the tribunal, but also for internal grievances, internal complaints. So whatever decision you are unhappy with, or your member that you're representing is unhappy with, you need to look at the employer's explanation. Is it a reasonable explanation? You know, is it consistent with past treatment? So for union officers and for branch officials, this is where you're at a much you're at an advantage. Really, you would usually, you know, a branch officer may know much more than just an employee who brings a grievance by themselves, because that branch officer or a colleague in the union may have dealt with a similar case where someone's been treated differently. So you need to try and gather that kind of evidence. And by that, I mean sort of comparative evidence. You know, have a look at what's happened in the past. If someone's been disciplined, did they get the same kind of warning? Did they get, you know, a lower warning than your black member? See whether there's sort of evidence of stereotypical assumptions, reactions. See evidence of singling out. So, you know, same as what I've said before, when you're comparing someone's treatment, see if there's other people who've received similar treatment or not. If the behavior is unreasonable, that may be discrimination, but also remember, if you show unreasonable behavior, that on its own won't get you very far, because you'd have to show that unreasonable behavior is on grounds of race. Look at the employer's policies. Are they breaching the policies in this case, whereas in other cases they haven't breached the policies? Look at the EHRC employment code. It's available on the EHRC website, and the employment code, although doesn't have evidential value in the tribunal, tribunals can take the code into account. So I'd urge you to have a look at the EHRC employment code. It's got some really good examples in the code of the type of. It's got some sort of real case examples, as well as sort of practical examples on what employers should do. Next slide, please. Okay, I'm running out of time, so I'll go through this very quickly. Time limits. You've got 3 months less 1 day from the act of discrimination to bring a tribunal claim. If it's continuing discrimination, so if it's harassment, for example, which you've suffered for months and months and months, the deadline starts from the last act. And if you are late, the tribunal does have discretion to allow late claims if it's just and equitable to do so, but I wouldn't rely on it. Always remind yourselves, remind your members of the deadline, because there's a risk that you can't pursue your claim if you're late. Next slide, please. If you're successful, the tribunal can order one of 3 things, or all 3 things. Firstly, a declaration that you've been discriminated against. And that doesn't sound much, but for some people, it means a lot. Even if you don't get any compensation, the fact that your claim has been upheld means a lot to many people. Compensation is made up of any loss of money as a result of the discrimination, as well as something for the hurt you've suffered, injury to feelings. You don't get injury to feelings in every type of case. So if you brought a claim for unfair dismissal, you wouldn't get compensation for hurt feelings. So you only get compensation for hurt feelings in discrimination cases. And occasionally, an employer the tribunal may make recommendations inviting the employer to follow those recommendations to remove the discrimination or the disadvantage suffered by the employee. So an example would be where someone's been harassed by a manager on grounds of race. A recommendation could be that the employer is required to move someone, the manager, the perpetrator, from that team, so that the victim doesn't have to face the perpetrator. Okay, well, thanks for listening. I'm sorry I've run over time.
No problem at all, Rakesh. I'm sure everyone found that really interesting and worthwhile. So thank you for your presentation. I'm going to move to Marion now. And I think we were only scheduled, I think, for the total webinar to be an hour, but seeing as we joined late anyway, I think we'll try and push it to 4:15 so we can get some of your questions in, and hopefully you can all stay a little bit longer. So over to you, Marion.
Great. So sorry, I can't move my own slides now. So I'm just going to talk a little bit about the union's work around this and cases that we've taken. The slides are all going to be sent out to you afterwards, and there's a recording going on as well. So I'll let you read through the slides in your leisure. But it's just at the beginning, as Philippa said, Prospect's legal team deals with the employment law cases for both Bectu and Prospect. And over the last couple of years, I must say, Bectu members have been keeping me personally very, very busy. So really glad to see that there's lots of activity going on there. So as I said, I was going to talk about some of the cases that we've dealt with. I think Rakesh has done such a really good and thorough explanation of a lot of the law that I won't go into too much detail. I'll just give you a flavour. All this information is on both unions' websites, so you can check out a lot of the details on this. This slide is simply a leaflet that we did last year for Union Week, and we were really celebrating the fact that the Equality Act was 10 years old, and we talked about some of the milestone cases that we'd had for members during that 10 years. And as I say, the link's there and you can look at that later on. So a couple of my two sort of real highlight cases that prospects had over that time. Firstly, actually very common that we see a lot of cases around failure to promote. I think that glass ceiling really operates quite stringently in terms of race in far too many companies. So it's a big part of our caseload on this. But this was the case that Rakesh talked about earlier on. So this was the case of our member Graham Dean against the Home Office. And it's all about a discriminatory process in assessing people for promotion. Graham won his case, and as part of that, the tribunal made recommendations for improving the situation. The Home Office had to change all their procedures. So that was a good result for our one individual member, Graham, who got promoted, got compensation, but also a knock-on impact for everybody else working within the Home Office. But that led to a further 50 claims being submitted. There was just at this point one prospect member and lots of PCS members, and that went to Thompson's to run all the way to Supreme Court. And Rakesh talked about all the legal implications of that, but I do think it's a really good example of how a collective union case secured over £1 million in compensation for members. So really good, positive message about the difference that unions can make. My other big favourite case has to be Mohammed Naeem and the prison service. This was a case that Prospect ran about indirect discrimination in pay. Photo there shows us all at the Court of Appeal, but it also went up to the Supreme Court. Now, the strange thing about this is that poor Mohammed didn't get a penny out of this case. He actually lost on the facts, but he was really determined to push this as far as the union was prepared to go, because it really made a difference in terms of how you assess indirect discrimination cases in the future. So it was one case where I often find with discrimination law that members are bringing cases because they're so committed to the point of principle and the equality and justice and pushing that in the workplace. And Mohammed really sort of did well in terms of pursuing that case all the way, even though it benefited thousands of people. I mean, it's a really significant case. But as I say, sadly on the facts he lost, but it's still a great success overall, and he would be saying that as well. Few other less famous things that we've been dealing with, lots of cases on harassment, I'm afraid, and Rakesh talked about the legal test for that, so I won't go into that. But something we've seen quite a lot of in the last few years is cases of discrimination and harassment against people of Muslims, and a whole sort of discrimination in the workplace about discriminatory comments, Islamophobia, and very horrible ways of treating everybody the same, and talking about some of the terrorist incidents and things that have happened here. We had a couple of cases of those in 2018, completely separate cases. That just shows how rife it is. Both cases settled out of court, and I think that's one thing to remember about discrimination cases, that so many do settle out of court because employers are not going to want to have all that out in public. But it's still really important, I think, that the union is seen to be pushing those cases and pursuing the issues. And I'll come back to that point about the added value of trade unions just before we finish. We've currently got 3 cases in the tribunal awaiting hearing on racial harassment at the moment. And I think an important point, particularly for the Bectu sector, is that this does cover the broader group of workers. So many freelancers will be covered by harassment and discrimination law, as Rakesh said at the beginning. Some other cases that we've been running, victimisation. Sadly, a member who won his claim of race discrimination a couple of years ago was then passed over again for promotion. And we argue that that's because he brought that claim of discrimination in the first place. That's the victimisation category of cases that Rakesh was talking about. Particularly within the public sector, we've seen several cases of discrimination in respect to performance pay, where we can show, when we do a complete equality audit, we've often seen that BAME workers are being disproportionately adversely affected by performance assessments and performance pay. And where we've analysed that across the piece, it tends to be most significant in terms of race and also disability. So lots of areas there where we've challenged, and we've had a number of cases in the public sector challenging that. Most recently, big case that was settled through judicial mediation last year in the tribunals. And as I said at the beginning, several cases around the issue of failure to appoint people to jobs or failure to promote. So a whole range of things. Advice and resources. I'm sure lots of you will be familiar with the resources the union provides, but just a little reminder on this slide. So within the union, I'm sure you know that members will raise issues with their full-time official in terms of seeking legal advice, and the full-time officials will then contact the legal team for further assistance. When we're running cases, we would normally be instructing counsel to represent our members in the tribunal. Rakesh mentioned about the time limits, so that's probably the most important message that either of us can give to you today, that that 3 months time limit is really strictly applied, and we need to be geared up to be able to get the advice to the member in plenty of time to start proceedings. I think it was just last year we produced this resource pack for reps and members for BAME workers, and that's the link that's on the Bectu website at the moment. There's also a member's guide to equality at work. So if you want a sort of shortened version of Rakesh's presentation, then that member's guide has got the sort of nuts and bolts of that, which you might find useful. Really, my last message to you is about the union message in all of this, that how did this grandly organise, agitate and litigate? And if you see me do other webinars on other issues, that's often my main message, because I think we can show that by joining together, we can make a real difference. And whilst this presentation is all about using the law, of course, the union is really uniquely placed to negotiate and take up collective issues. We win a lot more out of the courts and in the workplace through grievances, through negotiating, through collective bargaining. And that's really, really important. And we can only really do that through a strong, well-organised union. If you're on this call and you don't know about the networks, then there's a network for BAME members, and the link is there on the screen at the moment. And as I say, you'll get this sent out to you later. So whilst, yes, the law is there to be used, and it's certainly something that we will use, it's always better to prevent discrimination happening, which is really the sort of key motivator of the union in the workplace, where we will try to organise to create a fairer environment for all members. But of course, where that fails, then Bectu and Prospect absolutely committed to robustly using the law to fight harassment and to promote equality for all our members. So if you'd like to know more about any of our cases, check out the links on the slides, and do feel free to get in touch with the union about information. And I'm going to leave it there, because if it's anything like our usual webinars, I'm sure there's lots of interesting questions. So that's it. I'll stop sharing.
Thanks, Marion, and thanks to Rakesh again. So I'm going to look at the questions. I'll look at the Q&A first, although I think there are also a couple of questions in the chat, so bear with me. So the first question we've got is it's from someone who's anonymous on the chat. What evidence should people produce? If you can't use your mobile phone as evidence, as in certain workplaces you can't have your phone whilst on duty, what do you do? Do you want to have a go at that one, Marion?
Well, I'm presuming that's in terms of recording incidents of harassment and discrimination at work. And there's been quite a lot of case law about tribunals actually being prepared to listen to recordings that have been taken without the other party's knowledge. Generally, we'd say don't do it unless you really have to. And as a practical point, actually trying to rely on recordings in a tribunal is really difficult, because the tribunal is not going to sit there and listen to an hour's worth of a meeting. So I'd really rather not, and I'm a bit old-fashioned, but I'd rather you have somebody with you at meetings who can take a note, and we can present written notes. Tribunals like that much more. Don't know whether you want to add anything to that, Rakesh.
No, I'm old enough to remember, you know, pre-mobile phones. So we did still bring claims. So, you know, I mean, you can rely on written evidence of other witnesses who may have witnessed something. Obviously, it's sometimes difficult to persuade colleagues to come forward because they may be worried about their own position. But yeah, I'd be careful about secretly recording something unless you have to, because you could be in breach of your contract of employment as well if you've secretly recorded someone without telling them.
Okay, thank you. And again, another anonymous question. If you do have dreadlocks and someone refuses to give you a job unless you cut them off, but you're not a Rastafarian, can you take legal action? Is there anything to protect Afro hair in the workplace in general? Rakesh, do you want to have a go at that one?
I mean, you may be able to, if you say that the dreadlocks are part of your identity and you fit into one of the protected characteristics. So if it's a religious thing, or if it's a, I think what else. Generally, you'd have to show that you fit into one of the protected characteristics, or if the employer has a dress code, and if you're a woman and you've got long hair and they're asking you to cut it, but others, you may be able to show that may be discriminatory, but you'd have to show that the dress code itself is discriminatory. There's nothing wrong with employers, but it provided that the dress code applies equally to men and women, not exactly the same, but if there's a dress code that you need to be smart, then women are required to wear trousers or a smart skirt. Obviously, men can argue that you can't, as a man, say you don't want to be smart as well. But generally, it's very difficult to bring a claim unless you can fit into a protected characteristic.
Thank you. And we've got one here from Anne who's saying, do we have any examples of racial discrimination, English versus Scottish and vice versa? I asked because a female colleague was sexually assaulted in the workplace. I intervened and called security, and I was subjected to mocking and harassment because of my accent. The employer and police weren't interested in either issue.
Yes, you can. I mean, in Scottish, the Scottish background is seen to be a national origin, so you could bring a claim. that sounds to me like it would be harassment, but I don't know when that was, when it happened. Mocking someone's accent would clearly fall within the definition of harassment, but it would depend on when it happened and whether you've got proof. And if it's more than 3 months ago, then it would be very difficult to now bring a claim.
Okay, and Anna's also asked, can you discuss positive discrimination in recruitment, where a less qualified candidate gets the job above the best candidate based on the colour of their skin? So I guess that's the question about, can you specify on an advert that you're particularly looking for somebody with a certain characteristic?
Generally, you can't, unless it's for a training purpose. So where there's you're able to show there's a real deficit of certain types of, say, ethnic grouping within a workplace, and you're providing some form of training, and you so it's like a training contract. But otherwise, unless there are sort of exceptions within the Equality Act, so if the job itself needs someone of a particular background, and you can show that it's justified. So there are sort of religious organizations where you may have to be, in order to do a particular job for a religious organization, you may have to be part of, be from that, have that religion. So if you work in an admin job for a church, you may not need to be part of, belong to that church. But if it's doing more than just an admin, then you may need to be part of the church, in which case the employer could justify it.
Okay, thank you. And I think this will probably be the last one. If you have to complain to a manager and the manager is treating you unfairly and they deny it, how do you pursue it further? I mean, I guess as with building any sort of case, it's really around, have you got any witnesses? Keeping a log of what you think is unfair treatment, and so that you can build the evidence, I suppose, for the case in the same way as any other sort of grievance that you might have. Would you agree with that?
Yes, it's difficult sometimes, but it's difficult in court as well as in the workplace, and unfortunately, generally the legislation tends to sort of side with most employment law. Is there to protect employers rather than employees. But yeah, I mean, you'd have to gather the evidence and work quite hard at it.
Indeed.
And I think just on that though, I mean, that is again one of the differences, that if you're working in a unionised or an organised workplace, then the union reps can go in and start talking. And often we will take up harassment issues or discrimination issues anonymously, so we can have the reps going in talking to management about issues without naming you, so you're not exposed by that. And you can get a lot of advice and guidance in the union publications about recording information. There's lots of information on that in the members' guide. And I think, again, it's not just about the legal answer, it's about practically how we can tackle these things in the workplace.
Absolutely. So yes, Marion's right. Talking about behaviours or cultures is a really important part of what the unions can do, and looking at whether or not policies and procedures really do the job they're meant to do in a workplace. So I absolutely agree that if you take one thing away from this, it probably should be that, join a union, get colleagues to join a union, be active in that union. And as Rakesh has said as well, taking a case is not always necessarily easy because of the evidence that you have to be able to produce, but it's certainly worthwhile getting early advice on a situation if you feel that there might be race discrimination at play. So we are now at 4:15. Sorry if we didn't manage to answer your question. I just saw one there from Dennis, who's really making the point about the creative industries, I expect, and you know, the problem for the problems that we find for freelancers in particular to find work and to be able to progress within the industry, because if you know, quite often they will find if they make a complaint or raise an issue, then that's the end of their work in that particular, with that particular production company or whatever. And that's certainly something that we're attempting to address more broadly as a union, the real issues for freelancers across the creative industries. So thank you very much for your time. Sorry if we didn't get to all of your questions, but can I just finish by saying thank you to Rakesh and Marion for your really interesting and informative presentations. And as Marion said, if you want to know more about what we're doing, then do look at the website and those links. And as she also said, we will be sending around the slides with the recording of the webinar if you want to revisit anything. So thank you very much to all.